In early 2010, the West Virginia legislature made some significant changes to the state laws concerning driving under the influence. That's DUI. I'm Dan Ringer, and we'll talk about the new DUI laws right now on the Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
Typically, people have to drive to work or they risk losing their jobs. They also have to drive to get food, clothing, and medical care. But if you lose your license as a result of a DUI case, you can't drive. My guest is attorney Neil Hamilton. Neil, welcome.
Hi, Dan. How are you, sir?
Good to see you again. It's been a while since you've been here.
Thank you.
We talk about DUI. What does DUI mean?
Driving under the influence of alcohol, controlled substances, or the combination of alcohol and controlled substances, where it affects your ability to operate a motor vehicle.
In controlled substances, we usually think of evil drugs like heroin or marijuana or some of those things. That's not literally what it means, is it?
No, it's actually any controlled substance. It could be antidepressant medication. It could be lots of things you get from your doctor.
Anything that probably anything that says on the bottle may cause drowsiness or words to that effect. You have to worry about those things.
Right. Avoid operating a motor vehicle. They'll usually give you warnings, but some drugs can be taken in higher doses than doctors recommend, which would give someone a problem driving a motor vehicle.
Or prescription drugs can be taken by people who don't have the prescription.
Correct.
So all of those things can get you in trouble for driving under the influence. We used to talk about DWI, which was driving while intoxicated, but we finally came to recognize that people weren't just drinking alcohol, they were using other things, and it was interfering with their ability to operate a motor vehicle. Well, what happens if you get caught and the police suspect that you're impaired in some way while you're driving?
Well, they will perform field sobriety tests, make a determination as to whether or not they think there's probable cause to arrest you. Those field sobriety tests can be the walk and turn test, the horizontal gaze and nystagmus test, the one-leg stand test. They can give you a preliminary testing device of your breath on the field. And then if they arrest you, they'll take you to the station and ask you to submit to a secondary chemical test of your breath.
And what would that be?
Now it is the Intoxilizer. It's the ECIR2. It's a breath device that our state law enforcement uses, and they will do a waiting period and then require or ask you to blow into the machine.
The waiting period's to make sure you haven't consumed something between the time you're stopped and the time they take the test that would interfere with the test.
Correct.
And that's the one that you see on TV, if I think this is the right machine, where you blow into the tube until you turn blue in the face, and then the machine tells you.
A long, basically a long sustained breath is what it takes. It's not breathing hard into it, it's a long sustained breath. It's to get the lower lung air.
Well, how drunk do you have to be then to be driving under the influence?
Well, if you're under 21, we have measurable alcohol, which is below 0.08 or 0.08% of weight of blood in the bloodstream, of alcohol in the bloodstream. If it's a regular DUI, whether you're under 21 or over 21, it's 0.08 or more, or 0.08%.
And then there's another category if your blood alcohol is much too high.
In 2008, the law was revised and they put a category called aggravated DUI. which is where someone has a blood alcohol content, or BAC, of 0.15 or more. And it provides for stiffer criminal sanctions as well as stiffer administrative sanctions for people's licenses.
And that's what we're going to talk about here in a few minutes. What are those criminal and administrative sanctions, and how can you deal with them if you are stopped? The less than 0.08 blood alcohol level, and you said detectable amounts if you're under 18, that would mean that you're driving under the influence, or maybe driving under the influence, even if you can't tell you've had something to drink. It just has to show up in your blood.
Well, that's correct. Now, measurable alcohol is for anyone under 21.
Yes, under 21.
21.
Okay.
If they detect it, I mean, it doesn't take a lot to be 0.08, really, depending on your weight, depending on what you've eaten, when you've eaten it, how much you drank. You can drink a couple beers and be a fairly light-framed person and be under the influence.
Or not have anything to eat with it.
Right.
One of the things that affects your blood alcohol level is how quickly the alcohol is absorbed into your system. And if you're drinking something on an empty stomach, it's going to be absorbed pretty quickly. And most people who drink will tell you they can tell whether they've had something to eat or not. But if you've been drinking at all and you're under 21, you may have a half a glass of wine or a couple of swallows of beer, and you may be technically under the influence if the police stop you. And we could debate whether that's fair or not, whether it makes sense or not, but it's the law.
Correct. And you know, our laws are designed that if you are under 21, you're not to consume alcohol. So if they can detect it, if it's 0.02, 0.02% or more, up to 0.08, you'll be charged with driving while under measurable alcohol.
We're talking about the new West Virginia DUI laws. My guest is attorney Neil Hamilton. I'm Dan Ringer, and this is The Law Works. 0.15 is pretty far up there.
It's up there. It's double the legal limit presently.
I've always told people, and I've kind of looked at my own experiences, not that I've ever had my blood alcohol measured, so I've never been stopped for anything like that, but I always thought that 0.08, the typical DUI, you're drunk if you're over 0.08 and maybe not if you're under it, is a discernible amount for you. If you can tell you've been drinking, then you probably ought to stay out of an automobile.
Well, that's true. And in this day and age, I mean, I hate to say it, but it's not wise to drink and drive at all. I don't think people can take that chance anymore.
Well, your reaction times really are affected. We've seen test after test after test of somebody drinking a little bit, drinking some, and drinking a lot, and to see how their ability to operate a car or a blender or pretty much anything else is affected. And you just shouldn't. You just ought to stay away from it. Sometimes that's hard. You go to a party or you go to dinner and you have a glass of wine or you have a couple of beers, then you go out and you get in the car and you think, I'm okay to drive. The fact that you have to think that probably means you're not okay to drive. Well, the question comes up. If you have to, it's one of those typical situations where if you have to ask the question, you don't want to know what the answer is.
Well, of course, I do DUI defense, and I'm the better alternative is not to drink and drive. But there are people that are not under the influence that are okay to operate a motor vehicle. They've had a full meal. They've had 1 or 2 glasses of beer or wine, and they're okay. But there's plenty that don't do that.
Well, the legislature has sort of recognized that some people may be okay, but they're violating the law anyway. And just this past legislative session in 2010 made some accommodation in the law for that. What accommodations have been made?
As of June the 11th, our new legislation allows for a deferral program or a conditional probation in circumstances of a true first offense DUI. It's an interesting concept. If someone's arrested for a first offense DUI, within 30 days of the date of his or her arrest, they notify the court of their intention to participate in this deferral program. Then, basically, according to the statute, they can, they'll either enter a plea of guilty and the court not enter a judgment on that guilty plea, or they can go to trial, because it says plea or finding of guilt by the court. Once they enter that deferral program, the court then, without entering a judgment of guilt, places them on probation, and as one of the conditions of that probation, they have to go through the alcohol test and lock program. And they actually have to do the program as a first offender a little longer than what a first offense DUI person would normally have to do. It's a 15-day revocation, and the test and lock program for 165 days, which is 5.5 months.
So if you are arrested and charged with first offense DUI, now sometimes, Neil, people get charged with first offense DUI more than once. Is this for any first offense DUI? Well,
from what the statute says, it looks as if they have not had a prior revocation before or conviction, they'd be okay. And if they were charged with, let's say, an aggravated DUI that was criminally reduced to a first offense, if they didn't have any other prior offenses, they should be able to get into the deferral program.
How many times can you do the deferral program?
Only once.
One bite at the apple.
One bite at the apple.
So if you recognize that the arrest for DUI was justified, that you probably were driving drunk, you recognize that fact, you have 30 days to say, I'm not going to contest this, I would like to enter this deferral program.
Well, you have 30 days to notify the court of your intention to do that. And I say that because in the wording of the statute it says enter a plea or found guilty. So it implies to me that if you think you were borderline and you go to trial and are found guilty at trial, that you would still have the ability in a first offense case to take the deferment before being adjudicated guilty by the court.
Okay. So you get into the program and the criminal process stops, freezes.
Correct. You are placed on probation. Probably most courts are going to do, I would say, it'll be up to the court. The only mandatory condition is that you complete the test and lock program, which means that you have to complete the safety and treatment program too, because you have to do that as part of the test and lock. But I would say most courts are going to put people on probation for at least a year.
So the education program, that is with a counselor of some sort. The setting, I suppose, could vary depending upon what particular program you enter. But it's basically an alcohol education program.
Right. It's an approved state mental health facility like Valley Healthcare System or the Summit Center.
Any community, they used to call them community mental health centers. I think they call them now community health centers. Well, what's test and lock?
Oh, it's affectionately known as the blow and go. It's an interlock device that's attached to the vehicle, to the ignition, and you have to engage this device before the vehicle starts, and if you have alcohol in your system that it detects, it won't allow you to start the vehicle. Periodically, while you're driving the vehicle, there will be a signal that requires the person to blow into the device.
While you're driving?
Mm-hmm. Yes.
You actually blow into the device while the car is moving?
Sometimes. When there's a signal, you have to...
Hopefully you're not on the cell phone at the same time. That sounds a little strange, but okay. So you do this for how long?
Well, in a true first offense DUI, if you didn't take the deferral program, you would have a 15-day revocation, loss of license, or loss of privilege to drive, and then the lock and test would be for 4 months. In the deferral program, it's a 15-day revocation and 5.5 months on the lock and test device, at a minimum.
So every time you want to operate your vehicle, you have to blow in the tube. The computer has to say, okay. Who monitors whether you're trying to drive when you're drunk or failing the test in some way?
Well, our state has interlock division set up, and they have centers around the state that people go to. Obviously they can't drive there. They have to have a licensed driver. You have to have the permission of the owner, or own the vehicle yourself. You can even have more than one device if you have to drive multiple vehicles. Someone has to drive you there. It's a lawful operator. You have to have proof of insurance, registration. Then the person that's going to have the device on their car, they have to go get an interlock license. They have to actually go to the DMV and get a special license that indicates they can only drive an interlock equipped vehicle.
Special driver's license, photo ID. We're talking about the new West Virginia DUI laws. My guest is attorney Neil Hamilton. I'm Dan Ringer, and this is The Law Works. So you have the device installed on whatever vehicle or vehicles you're going to be operating, but do you have to go back from time to time to have the computer looked at to make sure you're doing it right, or does this thing call somebody and say, no, he's trying to get in and he shouldn't? How well, technically does that work?
You know, I work mostly from a court perspective, but I do understand that most of these places have them go back every couple months, unless there's a lockup. You know, if the device locks up, then the driver's got problems.
And when does that happen?
Well, if the machine detects measurable alcohol.
So it's not a matter of the machine telling you you've got alcohol in your bloodstream, come back when you're sober. It's a matter of you've got alcohol in your bloodstream, you can't drive until this machine is reset. That means you've got to go explain yourself.
Yes, there is I understand there's a mechanism in that you know, you can, if it may reset, you can try it again if it may have detected another interferent. Because some people, I understand, they're not supposed to wear colognes or drink certain things, or like gargle with Listerine, scope, things that have alcohol, but there are other things that the machine might detect as.
So it's conceivable that the machine will give what we might call
false
a false
reading.
Positive, a false reading.
Yeah.
Well, you get into this program, you complete the program, then what happens?
Well, in the deferment, or just if you've completed the regular safety and treatment course and the interlock, the interlock will notify that person that they've completed it, take the device off the vehicle. I require my clients to get a letter from them that says that they've completed it. At that point, if you're in this deferment program, you'll go back to court. You'll file an affidavit that you've completed the program and the conditions of probation that the court set, and you'll serve that motion on the prosecuting attorney, and there's a 30-day waiting period. And if the prosecutor doesn't object, then after that 30-day period is over, the court shall dismiss the case.
You say shall, that's what the law says.
That's what the law says.
Now, it just doesn't happen automatically that you go back to court. You have to file what's called a motion to dismiss the case, and in that motion you would say, I was required to do A, B, C, and D. I've done A, B, C, and D. There have been no improper actions, no unintended consequences. This case should be dismissed.
Right. And it says it should be supported by affidavit. So you, the defendant, will swear to that in the form of an affidavit with his supporting material that he's completed the lock and test program. And of course, if the prosecutor objects during that 30 days, or if the prosecutor thinks there's been a violation of the program during the probation period, then the prosecutor would file a motion with the court and bring it for hearing in front of the court to determine whether or not that person has in fact violated the terms of the probation. And if the court finds that they have, then there will be an adjudication of guilt. They already entered their guilty plea or were found guilty. The court just before held back on entering judgment, and now the court would then impose sanctions and enter the judgment of guilt.
And there's something else. If you successfully complete the education and the test and lock program, which is called the test and lock program in its entirety, after a year, you can ask to have your records revised.
After 1 year, which begins at the end of the dismissal or the completion of the probation period, you can apply to the circuit court for an order of expungement. What that means is you can ask the court to erase the criminal records of your arrest and the processing and the, let's say, magistrate court proceedings, the prior court proceedings. But it doesn't erase the DMV records. It would not expunge the driving records.
So your criminal record, insofar as this arrest for DUI is concerned, would be cleaned.
Would be gone. Mm-hmm. Yes.
And in fact, the statute says you can deny that it ever happened.
That's correct.
So far as the criminal record is concerned. What's the significance of the fact that DMV does not expunge their records?
Well, actually, I said you only have one bite at the apple. The statute infers that a subsequent conviction would include not only a prior DUI conviction, but also where the person was granted a period of probation or deferment for the first time.
So you get treated as a second offender by the Department of Motor Vehicles.
That's certainly what it implies, yeah.
If you do it again. And the upshot of that is you've had advantage of this test and lock program. You get your driver's license back quicker, although you do have to do some things that you might not otherwise have to do. But if you come back the second time, the Department of Motor Vehicles will suspend your license for a longer time. In fact, actually a much longer time than they would have if this was your true first offense. But criminally, I don't know, are you going to be prosecuted then for a second offense the second time around? Sure
seems to imply that. I do want to clear up something, because the new deferral, it isn't available for in every instance. You have a true first offender charged with a non-aggravated DUI. It could include a person charged with an aggravated DUI or an implied consent violation that actually was prosecuted or pled guilty just to the regular DUI. But it doesn't apply to people that have commercial driver's licenses.
What does that mean? What's a commercial driver's license?
A person who has a special operator's permit that allows them to drive public transportation or a commercial vehicle.
Who drives for money?
Bus, yes.
So if I'm a truck driver and I get a DUI, this is not available to me.
That deferment would not be available to you.
And we see a lot of those.
It does happen. In addition, the deferment, the expungement would not be available if the person had a prior felony.
Of any sort?
Of any sort. And they also have to not violate any of the terms of the probation during the probation period, or have any repeated or subsequent conduct that would be a violation of probation before they file their petition for expungement. So even though it's technically you have that year probation, you still have to be a good person, not have any violations, even though you're not on probation, if you want to petition for the expungement a year after it's dismissed.
It sounds as though, and I can't get into the mind of the legislature, and perhaps you can't either, maybe you can. It sounds as though the legislature looked at what people really do and said, look, if you make a simple mistake and you're not too drunk or not too intoxicated, and you've never done it before and you haven't gotten in any other kinds of trouble, we're going to cut you a little bit of a break here.
I agree. I think that's true.
But we're not going to do it once. So be careful.
That's true too.
What does this interlock device cost?
Well, it's about, okay, first of all, you go to the center. You have an installation fee. It's roughly about $2.50 a day, $2.70, something around that.
For about 5.5 months.
For about 5.5 months.
And there are some provisions made for indigents, people who cannot afford to pay that, but you have to go through some additional requirements to do that. Neil Hamilton, thank you.
Dan, you're very welcome.
It's good to have you here.
Pleasure to be here.
Thank you. Thank you also for being with us. On behalf of the LawWorks, I'm Dan Ringer. Good evening. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks program topics and additional information about this show's topic. If you would like to recommend this program to a friend, you'll find a video of the program at the LawWorks website. You'll also find free video and podcasts of previous programs on YouTube and iTunes. If you would like to suggest a topic for a future program, or if you're a school teacher and would like to receive a free copy of this show for classroom use, send us an email to thelawworks@comcast.net.
The LawWorks is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The LawWorks is made possible by the generous support of the West Virginia State Bar, the Monongalia County Bar Association, and by a major grant from the West Virginia Bar Foundation, promoting public knowledge of the law in West Virginia. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system.
From West Virginia Public Broadcasting.